deal in the matter of Amdocs Systems Group Ltd and Langton.
Yes, Mr. Cohen.
Morning, my lords and my lady. I appear for the appellant. Mr. Leach appears for the respondent as below.
Yes.
This is, in reality, a single issue appeal. Does the summary of benefits provide for a contractual right between employer and employee to what has become known as the escalator?
Yes.
And will no doubt be a familiar concept to this court, having done some pre-reading. There is, of course, only one right answer to that question, it being an issue of the interpretation of written documents. And it follows that I ought to get to the language as quickly as possible. Of course, my lords and my lady have seen it, but nonetheless will want to hear from me as to what I say it means.
Yes.
Having said all of that, there are two short diversions I think that I will need to take from the contractual language. The first diversion is to look very shortly at what both the Employment Tribunal and the Employment Appeal Tribunal found. Now, I recognise that in one sense that doesn't matter, because the answer at this stage it is what this court finds the language means, but nonetheless I think useful to look at it very shortly, if only because I'd like to show you where I say they went wrong. And the second diversion is to look at the 4 decided cases of the appellate courts about permanent health insurance. And I say that because it would be unrealistic not to recognise that the courts have taken a certain view about permanent health insurance rights, a protective view, and one has to see what's going on in those cases to determine whether there is any learning that one can obtain about the facts of the incident case. What I would say about that in short is no, but I'll need to explain why by reference to those authorities.
Well, that seems a very helpful route to follow.
I'm very grateful for that indication. Could I start by dealing with what the court's tribunals below have found? I'll then go to the language and give you what I say is the correct interpretation of that language, and in the course of doing that, I'll show you what the authorities have found, and we'll need to have a short tour through those. If we could start, please, with the judgment of the Employment Tribunal, which is at page 137 of the core bundle. And it's quite a long judgment, but what I'd like to do is to try and really get to the nub of how the Employment Tribunal arrive at the findings that they do. If we could start, please, at paragraph 86 of the judgment, which is page 165. And if I could invite my lords and my lady to read that passage.
Just 86.
Just 86 for the moment, please.
Yes.
So the first proposition of the Employment Tribunal, if I can put it that way, is that the summary of benefits is a set of rights and obligations which can take effect between employer and employee. It's not merely the description of an insurance scheme. And that's a point that we'll have to come back to in the course of this appeal, because I say it's wrong. And then we go on to paragraph 88. And if I could invite my lords and my lady, please, to read that.
Right.
Now, the interesting thing about that passage is that what the Employment Tribunal do is they focus on the language within the summary of benefits, and they determine that it's clear and certain as to the benefits payable under the respondent's, I should put some emphasis on that word, respondent's income protection scheme. What they don't do in either that paragraph or any following paragraphs is consider the language of the contract of employment, which I say is all important, in other words, clause 6, which in due course I will urge upon you. It is a signpost to where the rights can be found. So that's a judgment which simply fails to look at the contractual language used as a whole, because of course we know that the exercise of interpretation isn't just to look at a word here and a word there in isolation, but to look at the whole package and to decide what the contract means. And critically, the Employment Tribunal don't do that. We then go to the decision of the Employment Appeal Tribunal, and that is at page 72 of this volume.
Yes.
Now, by the time we get to the Employment Appeal Tribunal, there's less in issue. And there's less in issue because some points have dropped away because they're not appealed, and because the claimant has made a concession, and that's recorded at paragraph 29, page 85. And the concession at paragraph 29 is that if in fact the tribunal is wrong that the summary of benefits is the source of a contractual right to the escalator, then the claim fails. And just to understand the reason why that concession is made, which might at first blush be a surprising one, the reason it's made is strategic. What the claimant wants to do is to say that in the absence of there being any right in the manual, point I'll come back to in a moment, it's the summary of benefits which has to in effect fill the gap. And of course, to say that there is an absence of rights in the manual is not correct. We don't know what the version of the manual which was applicable to the claimant at the time he entered into his employment contract said, and that's because the version of the manual that was before the Employment Tribunal was from 2005, and for the first time at trial the claimant says, actually I don't accept that that's the manual which applies to my situation because I never saw it, despite the fact that he'd advanced his case to date based on that document. So there is an evidential void because we don't know what the 2003 manual version in place at that point in time said.
Well, whose fault is that, Mr. Cowan? You say this as though that's some kind of criticism of the claimant that he wasn't able to produce the 2003 manual.
So, Lord, can I make two observations about that? The first is it wasn't intended to be a criticism. The point that I am making is that there is a difference between a situation where a contractual document is silent on a particular right, which one would expect to be there, at which point in time concepts of implication may come into play, and a situation where one doesn't know what the document said, but there is no finding that it didn't deal with the particular issue. So that's the first point to make. The second point to make in terms of whether there is a criticism, I've said there isn't, but the position is a finely balanced one, and it arises in this way. Right up until the trial and indeed at the outset of the trial, the claimant's position was that the 2005 version of the handbook was the applicable one. Now, it's right to say that he had been given that document during his grievance process. So I'm not criticising him for relying upon it. But what he didn't do was to say, well, I was never given that. So it can't apply to me, because what the contract of employment says is that if the manual is amended, I have to be individually notified of that, and I wasn't individually notified. So not unsurprisingly, the employer proceeded on the basis that the 2005 manual was the applicable one. Now, I plainly couldn't at trial show that he'd been given any individual notification because these events were historic. But in circumstances...
Even if he'd said this in advance, you wouldn't have been able to find a 2003 manual.
I doubt it.
Well, there would be an application to put in fresh evidence, even at this stage, if you could.
Yes, but what we did do, again, I should tell the court this out of fairness, what we did do at the stage of the EAT proceedings was to admit that the summary of benefits was evidence of what the 2003 version of the manual was likely to have said. Because what we didn't want, we're not in the business of trying to cheat Mr. Langton out of his entitlements. We just want to get things right. So in circumstances where we hadn't produced the 2003 manual, we were prepared to accept that from the summary of benefits, one could discern what that document was likely to have said. And that, I think, is recorded in the EAT's judgment at paragraph 38. And that's page 88 of the bundle that you have open in front of you. So what we were prepared to do was paint the worst case scenario factual picture for us, that the 2003 manual did incorporate a contractual right to be paid these benefits by the employer. It didn't include any sort of time-to-time provision. And we did that not for any strategic reasons, simply because we thought as a matter of fairness, that's what we should do. But one might wonder why the claimant hasn't sought to grab onto that. And the answer is that he doesn't want to, because if the right is in the manual, then it's amendable pursuant to the employment contract. And what Mr. Langton doesn't want is an amendable right. What he wants is, what he says is a non-amendable right, which arises from the summary of benefits. And in those circumstances, he essentially seeks to go for what I might describe as jackpot damages, rather than an amount of money that might have been payable based on an amendable right.
But surely the right is amendable, provided that the amendment is expressly notified to the claimant.
Well, he would say, not on the basis of the findings of the Employment Tribunal and the EAT, because what both of those tribunals has found is that the right is one that is derived from the summary of benefits.
Yes.
And the summary of benefits is not amendable because the amendment provisions in the contract of employment permit amendment of the manual. And thus, by that line of reasoning, what Mr. Langton says is that he has a right to the escalator in effect for the remainder of his working career, if in fact he never returns to work. And there is a significance to that point, which I'll come to shortly when I deal with interpretation, which is that self-evidently, the reason for packaging up secondary rights and putting those rights in the manual and making the manual an expressly amendable document is that the employer wants to be, indeed needs to be, in a position where changes can be made to those rights. And it's inherently improbable and an important aid to construction that at the same time as preserving a right to amend the manual, what the employer does is express these rights in a different place so that they're not capable of amendment at all. In other words, they're preserving their ability to change with the right hand, but committing themselves forever to a particular right with the left. And that will be very important when we come to interpret the contractual matrix here and the language that's used.
Where does it say? I mean, you may be right, but I hadn't picked it up, that it was Mr. Leach's case that the summary of benefits is not only part of the contract, but it is unamendable for all time.
Oh, that's undoubtedly Mr. Leach's case. It will say that in both the ET and the EAT judgment. I'll just see if I can find the references very rapidly. If we turn to the Employment Tribunal judgment, yes, for example, if you go to page 160 at paragraph 74, it may be helpful if I just ask you to read the whole of paragraph 74.
So it's the bottom line of page 160, top of 161.
And that is the, if I can put it this way, in fact, the sole purpose of this appeal. That's the ground between us. Because if in fact the right, just refer to it as that at the moment, if the right can be found in a manual, it's expressly amendable pursuant to the written employment contract, and Mr. Leach would say if it's found in the summary of benefits, it's not, because nowhere in the summary, in the written employment contract does it say that anything that the offer letter says or the summary of benefits says is amendable. Yeah. And so the court is aware of it. What the employer has done is to reissue the manual, as it's entitled to do under the contract, to give appropriate notice of that to Mr. Langton, and to revise the permanent health insurance terms so it makes clear that he's not entitled to the escalator and that the employer acts only as a conduit for such payments as are received from the insurance company.
But that change isn't challenged in this litigation, is it?
Oh no, because if in fact Mr. Langton succeeds on this appeal, he would say that that change will make no difference whatsoever to his position, because his case is that the right doesn't flow from the manual at all. It flows from the summary of benefits. And one curious feature about the EAT's judgment, which I'll show you in a moment, is that at least in the Employment Tribunal, there is an attempt there by the judge to grapple with the issue of duplication of rights. In other words, the judge is alive there to the very curious position that if you find that the summary of benefits provides for a contractual right to the escalator, necessarily you're finding that it comes from, there are contractual rights about PHI which come from two places, because you've got a set of rights expressly in the manual and you have a set of rights in the summary of benefits. And what the employment judge does is to rely on clause 22 of the contract of employment, which I don't know if my lords and my lady have looked at very carefully, but it might be useful if I show it to you. Page 144 of the supplementary bundle. So
Yes.
Mr. Langton is alive to the problem of duplication. And he says to the Employment Tribunal, look at clause 22. What you should determine is that there is a specific agreement, looking at those words in the first line of 22, a specific agreement to PHI rights in the summary of benefits. So that means that because there is that specific agreement, you don't adopt and incorporate into the agreement, this agreement, i.e. the written contract of employment, anything the manual has to say about permanent health insurance. And the Employment Tribunal accepts that and says, okay, that's the answer. The right is only to be found in one place, which is the summary of benefits, not the manual at all, despite the fact that clause 6 appears to say otherwise. Not accepting my submission, but that would be bizarre, because one contract would be giving with the right hand and taking with the left. In other words, clause 6 would be incorporating what the manual says about permanent health insurance, and clause 22 would be stripping it out. In the EAT, the judge sees the force of that and interprets clause 22 in a wholly different way, and he's right to do so. And he says, well, clause 22 can't operate to take out of the equation what the manual has to say about permanent health insurance. And that leaves the position after the EAT hearing even odder, if I may say so, because following the EAT's judgment, you've got a contract which appears to say that the right is in two places, if the EAT is right. One right to permanent health insurance is in the summary of benefits. The other right is in the manual. One is amendable, one isn't. And that's the difficulty that the EAT's judgment gives rise to. I wonder if it might be helpful
That's your second point in your skeleton, isn't it?
It is. It is. That as a powerful aid to construction, it seems extremely odd that one would have a right in two places, and all the odder once one recognises that the manual is amendable. So why on earth would you find the right then being put in a place that makes it unamendable? It defies common sense and is very unlikely to have been what the parties intended.
Well, on your case, Mr. Cohen, the tribunal found, and I don't think it's disputed, that the three documents of the 25th of July 2003 were signed, handed over together. One of them is the offer letter, one of them is the summary of benefits attached to the offer letter, and one of them is the contract of service.
Yes, I'm not sure they went so far as to find that all three were signed and returned, but they were certainly sent together.
All right, they were all sent together.
Yes.
Surely they are to be read as a whole.
For the purpose of construction, yes.
Yes. Now, on your case, what is the significance of the summary of benefits document?
The summary of benefits document is an explanation of the terms of insurance cover then in place between employer and insurance company.
It has no other significance at all.
It has no other significance at all.
Right. And where do we find that?
So if, my lord, we go to page 138, in fact, let's begin please at 135 of the supplementary bundle. You have the offer letter at 135. You have the written contract at 137. And you have the summary of benefits at 145. And since we've got to the contractual language, let me make the points now about that language. And the starting point is to look at the contract, which is at page 137. And what the contract does is to set out a range of primary liabilities. So if you take an example of one of those, paragraph 4 provides for remuneration, critically important to the relationship, and it's therefore found in the contract itself. There are then a set of secondary rights, and they're secondary because they're not the sort of thing that necessarily arises as an important issue on a day-to-day basis between employer and employee. So, for example, if you turn to paragraph 6, one sees that there are, and I won't focus for a moment on the language at the beginning of paragraph 6, but there are a whole set of rights which are to be found in the manual: salary protection plan, pension fund participation, life assurance, equity participation, private health care. If we go over the page, paragraph 7, provisions relating to absence through illness shall be those set out in the manual. Paragraph 8, provisions relating to holiday entitlement shall be those set out in the manual. And paragraph 11, the manual is a living document.
Yes.
Now, none of that is unfamiliar, because typically that's exactly what one does see in an employment contract. The primary rights, such as, for example, remuneration, are not amendable. They're the pillars of the relationship. And the secondary rights are in the manual and can be changed unilaterally by the employer. And
on giving notice.
On giving notice, of
Yes.
course, of course. And one can see, for example, why those rights at paragraph 6 would be the sorts of things that would be put in a manual and would be made amendable, because you would expect them over time to change, not least because where you're dealing with insured benefits, even if the employer wants to maintain the same level and type of cover, the insurer may not be willing to offer it. The language of the applicable tests might change. So it follows that it would be extremely unlikely for an employer to bind itself to the same rights in respect of these sorts of things without having a unilateral ability to change them. So what that shows you at the outset is that it's very unlikely that there was a third place where rights could be found. And what it shows you is that where clause 6 says in terms that rights are to be found in the manual, that's explicable. There's a good reason for that. And it's even more unlikely that what the employer would then do is set them out somewhere else and make them unamendable. So that's my point number 1.
How is that reconciled with the wording of the offer letter? 136. 135, 136.
Yes.
And it sets out your remuneration package will be 6 lines down, an income protection plan.
Yes.
And then second page, it's under the heading income protection and sickness payments.
Yes.
Kramer will pay staff on sick leave their full salary, etc., etc.
Yes.
Please see the attached summary of benefits for further information about the above benefits.
Yes. My lord, there's nothing inconsistent between that and clause 6.
No.
So if we, again, you have to read all of these documents together. So if one goes back to clause 6, in fact, what clause 6 does is provide the necessary signposts. So looking at the introductory words of clause 6, the employee is told where to look. So the extent and the circumstances of the benefit are to be found in the manual.
Well, in the manual and outlined in the employee's letter of offer.
Yes, but the and is disjunctive. So the reader is being told different things. And that's inevitably so, my lord, because one could miss out the word outlined altogether. And if it said the employee is entitled to the following benefits to the extent and in the circumstances set out in the manual and the letter of offer, then that would make the signposting more difficult in clause 6, because it would tend to suggest that the words extent and circumstances applied to both manual and offer letter. But the insertion of the word outlined tells you that these two documents are doing something different. Extent and circumstances are to be found in the manual. Outline is to be found in the letter of offer. And what the word outline necessarily does, on its plain meaning, is to suggest that what is being dealt with in the offer letter is a broad description of something. It's an outline. It's not a right, at least not where clause 6 tells you expressly where the extent and circumstances can be found.
But evidentially, they couldn't be found because the manual wasn't able to be produced. And so the conclusion is that what's in the outline, in the summary, is likely, bounds of probabilities, to be on all fours with what was then in the manual.
So that's a point made by the Employment Appeal Tribunal,
yes.
I think, rather than the Employment Tribunal.
Yes, I think that's right.
But that, and so far as it goes, that may be right, subject to a point I want to make about the summary of benefits simply describing an insurance policy. That, let's just accept for the moment, my lord, that that's correct. What that doesn't do is convert the summary of benefits into a contractual document. What it could certainly do is be evidence from which a tribunal could find that the manual said X, Y, and Z, which was contractual. But I'm afraid it's simply unsound to say, well, the summary of benefits probably says the same thing as the manual would have said, therefore that's contractual. It just doesn't work. It's not right.
The summary of benefits is contractual because of the terms of pages 135 and 136, surely.
Well, as a starting point, my lord, you can't read those pages without looking at clause 6 at page 139. And I'll come back to the language in the offer letter in a moment, but the starting point is to look at 139 because clause 6 is critically important. As it's signposting, it is telling you that these two documents are doing something different.
So the 136 should have said, I've enclosed 2 copies of our document for your review and signing. please note that nothing on page 135 and 136 is of any value at all to the extent that it's contradicted in the manual. So you better read the manual carefully and understand that everything in the manual is amendable unilaterally by the company, whatever this letter may say.
It doesn't, my lord, need to say any of those things, because it's perfectly clear from the documents where the right is to be found. And I've shown you what clause 6 says, which I maintain is critically important to decide where one finds the contractual right. But if we go to the letter, there's nothing remotely inconsistent about the letter versus the contract, because if one looks at the letter, page 136, under the heading income protection and sickness payments, let me break down the two paragraphs there. Starting with the first of them, Kramer will pay staff on sick leave their full salary, less any statutory sick pay for the first 13 weeks they are ill. So that's plainly the employer indicating that it will do something. But what it goes on to say is that thereafter, an income protection plan has been established that will pay employees 75% of their annual salary, etc. Now, the difference in language there is notable, because with the first sentence having said Kramer will pay something, the second sentence doesn't do that. It uses very different language. I accept it doesn't refer to insurance, so in isolation you might read it as the employer saying it will do something, but it's not in isolation, because we go to the next paragraph and we see the words, please see the attached summary of benefits for further information about the above benefits. And I say equally, with the word outline that one finds in clause 6, to say that something is provided for information when clause 6 has said look at the manual for the extent and the circumstances, that is showing that this is not the source of the right. If we then go to the summary of benefits itself, page 145, there is nothing in the summary of benefits which indicates the employer is taking on any obligation to the employee to pay. So if we start under the heading Income Protection Scheme and Group Life Insurance Scheme, first paragraph, the employee is told that to protect from the loss of income, etc., the company have established an income protection scheme with Sun Life Financial of Canada. So the very starting point is the employer says, we've obtained a scheme. It's not our scheme. We're not operating a scheme internally. We've obtained an external insurance scheme for your benefit. When am I included? You are included in both schemes if you're an employee from the day you commence employment. Cease to be included in the schemes at age 60 or on ceasing to satisfy the eligibility conditions. What benefits are provided? Now this is important. Under the Group Income Protection Scheme, the payment of benefit commences after the first 13 weeks of incapacity, and you've got to medically certify for the insurance company. Now the word benefit is obviously very important, because what it doesn't say is salary. Benefit is something that's obviously very different to salary. And it dovetails with the provisions I showed you a moment ago in the offer letter, because just going back for a moment to the offer letter, you will remember that under the heading Income Protection and Sickness Payments at page 136, it's Kramer who are paying for the first 13 weeks. So you can see when you read that together with page 145 that Kramer pay for 13 weeks, and that's salary, and then it's benefit that takes over thereafter. And it's not Kramer who have to be satisfied of illness, it's the insurance company. We then have the reference to the escalator in the bottom two lines. If one goes over the page, how much is the benefit? For the group income protection scheme, the maximum initial benefit is 75% of your salary, less a deduction in respect of state benefit for a single person. So self-evidently, this is talking not about salary, but about some other form of payment which contrasts with it. And then the next passage is particularly important. Do I have to pay towards the benefit? No, Kramer pays the whole cost, which does not count as part of your income for tax purposes. So self-evidently, the reason it doesn't count as part of the employee's income for tax purposes is because this isn't a reference to Kramer paying the benefit, it's a reference to Kramer funding the insurance policy. Well, what that shows you is that Kramer isn't taking on the obligation itself to make a payment. It's a conduit for the insurance company's payments, which have to be paid PAYE, but what it is expressly saying it pays is for the insurance.
Yes, of course, but so what?
Well,
in terms of the law of contract, if Mr. Leach is right, summary benefits is part of the contract, the company have promised to procure the payment of benefits in certain circumstances.
But that doesn't take Mr. Langton's case where it needs to go, because this isn't a breach of contract claim. This is a claim for unlawful deductions under the Employment Rights Act. So it's not enough for Mr. Leach to show that the employer has a contractual obligation to procure the insurance. What he has to show is that the employer has taken on an obligation itself to pay, whether the insurance money comes in or not. And that's a very different point.
Was this point taken before the
Yes.
tribunal?
Yes.
And
And
there can't be any claim at all because it simply can't be
benefit
wages.
and not wages.
This is
The
an
point-
insurance benefit and not wages. So it's simply incapable of coming within the what used to be called the Wages Act jurisdiction of the tribunal.
The point that I have made about this document throughout is that what it does is to describe a policy of insurance. What it doesn't do anywhere is say the employer will itself pay anything. At the very highest, what it could be, don't necessarily accept it to be so, but at the very highest, what it could be is the employer taking on an obligation to procure an insurance policy, which is a very different thing indeed. If you look, for example,
I don't. If you answer my lord's question, what was this point taken directly?
yes. So if you,
below, because I'm bound to say I hadn't spotted it with the clarity that you're now submitting. That this
Tribunal simply has no jurisdiction.
this legislation doesn't apply to this case.
well, I don't think I put it in those terms. What I said was the employer has not taken on a contractual obligation to pay, because the
So
summary.
you said this is not to do with the contractual obligation. This is to do with the claim under whatever the legislation is, the Wages Deduction from Wages Act. And these are benefits and not wages.
Well, it's inherent to my case. So, for example, if you turn to the EAT judgment, and look, for example, at paragraph 32.
Thank you.
And if my lords and my lady look opposite paragraph letter C, this is summarising my arguments. It informs the reader that the respondent has bought an insurance policy and then summarises the terms of that policy. It does not purport to confer individual rights. It did not use language such as "we will pay you." So the point I have always made is that what the employer is not doing is taking on an obligation to pay. It's simply summarising the terms of an insurance policy that it has obtained.
Now, I understand that you're taking that as a point of construction of what does the summary of benefits mean.
Yes.
But I didn't understand, because this would be absolutely fundamental, that you were saying this is, even if the summary of benefits document is contractual, Mr. Langton simply brought his claim in the wrong forum. He should have gone to the High Court, and the Tribunal had no jurisdiction from start to finish.
But that,
Because if that's right, then that knocks out the whole claim, and one doesn't have to consider any other point at all.
but that, my lord, is... I apologise for not seeing the distinction. The point I was making is that the employer has not taken on an obligation to pay. It follows from that necessarily, I'm saying, there can't be an unlawful deduction, because the tribunal has to be satisfied that on a particular occasion the employer has paid less than it ought to have paid.
So that is the point you're taking. But it can't. The jurisdiction of the tribunal is to deal with an unlawful deduction from wages, and you're
Yes.
saying there can't be an unlawful deduction
Well,
because this is not wages. These are not wages.
I certainly didn't say to the tribunal, these are not wages. The way I was putting my case is that the employer is not under an obligation to pay anything. It amounts to the same thing, because the summary of benefits doesn't purport to confer any obligation on the employer. And I've equally made that point in my skeleton for this hearing. My lords have seen that, but it's at if one goes in the core bundle, it's page 23, paragraph 24, 24, 25, and through to 28.
Yes.
And that's not the first time I've made that point. I've been making that point consistently throughout. So one can view it as a jurisdiction point. I don't think I've necessarily looked at it as a jurisdiction point, simply that the employer was not under an obligation to pay. And we were not dealing with, couldn't be dealing with, because there's no breach of contract claim, the question of whether the employer was under an obligation to procure an insurance policy, because that just isn't the issue which arises in a case of this kind. No one has sought to argue that point, because it would have to be dealt with in a different forum pursuant to a different claim. Lords, my lady, if we just go back again to the summary of benefits, there was one final point that I wanted to make about it. And I've shown you the various parts of it that I say are just describing the terms of an insurance scheme. And then there is the final at 146. There is the final little bit of it under the heading Notes. The operation of both schemes is governed by the terms of the group policies, and nothing in this summary will override the terms of that document. Well, what the EAT said about that passage was that what it couldn't do is in effect incorporate the terms of the insurance policies at any particular time, nor was it sufficiently dynamic to take into account subsequent terms of insurance, because the reference to that document was a reference to the PHI policy which was in place at the time that the summary of benefits was drafted. But that finding too shows you that what this is doing is simply describing an insurance policy. What it's not doing is purporting to confer any right on the employee to be paid anything by the employer. And why is that critically important to construction? Well, thinking again about clause 6 and going back to clause 6 at 139, it's because the extent and circumstances are to be found in the manual, but the outline that one gets in the offer letter is an outline of the then insurance policy which is in place, and no more. And so all of this, even before one gets to commercial common sense, all of this works perfectly on the language. Yes, my lady, what I'd like to now do is go to the authorities.
Yes.
Before we do that, can we just look again at the offer letter?
Yes.
Suppose that the offer letter promises, among other things, life assurance up to 4 times basic annual salary.
Yes.
Suppose that, in fact, the company had carelessly failed to take out life insurance on Mr. Langton's life, and soon after signing the contract, starting work, he drops dead. Would you say that the company are not obliged to do anything because the promise was only a promise that some insurance company would pay 4 times annual salary in the event of his death?
Well, there are quite a number of variables in what my lord says. Let's just, if I may, just posit this example. The offer letter says, we will procure an insurance policy, which policy will pay X amount of money on your death, and the employer doesn't do it. What the employee then has is a claim for breach of contract against the employer for not procuring the policy it said it would procure. All of that assumes, of course, that what the offer letter says is contractually effective. And one would still have to look at all of the documents to determine whether in fact what the offer letter says is the source of a right or not. I mean, take this other example. One very frequently sees, and my lords and my lady will see it, one subscribes to an insurance policy, and what generally comes with the insurance policy is what is supposed to be a plain English explanation of the insurance rights, and frequently, if it's well drafted, it will say nothing in this document is intended to be contractual. You've got to look at the terms. But even if it doesn't say that, one has to look very carefully at all of the documents to determine where the right is. And in circumstances where there is an obviously contractual document which sets out the right, it wouldn't necessarily be the case that because a summary explanation that was given for information is wrong, that in some way trumps what the contract says. So it's a somewhat more complicated analysis than just looking at what the offer letter says. One still has to determine whether that is the source of the right. But I agree, my lord, in those circumstances, that if there was nothing to suggest that it was not intended to create legal relations between the parties, the employee would have a claim for, or the employee's estate would have a claim for breach of contract. I don't necessarily accept that that's the position here. I simply say that what this document is not doing is setting out a right or an obligation on the part of the employer to pay. The obligation of the employer is one that is expressly said by Clause 6 to be in the manual. And this is one further reason why the contract is clear.
Well, that's a different point as to what the manual says. But just looking at page 135, it says your remuneration package will be as follows: life assurance up to 4 times basic annual salary. I'm not clear what your answer is as to whether, if Mr. Langton had died the following month, whether he would, on your case, have been able to sue the company for 4 times annual salary. His estate would have been able to sue the company in the event that the company had carelessly failed to take out an insurance policy.
Looking at that example, if one goes to Clause 6 at page 139, life insurance is treated in the same way as the other forms of insurance. So the contract says extent and circumstances are found in the manual and outlined in the employee's letter of offer. It follows that the source of the right is in the manual, not the offer letter. If the manual says you're entitled to life insurance to 4 times basic annual salary and the employer doesn't subscribe for it, then there's no doubt, I don't think, that the employee's estate doesn't have a claim for life insurance.
But if the manual says something else, well, it's too bad. Then all you get is something else. 6 months or 12 months or a fixed sum.
If the manual says something other than 4 times basic annual salary, you get what the manual says. You don't get what the offer letter says, subject to any possible claim for some form of misrepresentation, because you are clearly directed pursuant to Clause 6 to the manual rather than the letter of offer. If the manual is silent, then I accept, as I did in front of the Employment Appeal Tribunal, that you might use what the offer letter says as a source of evidence from which you could discern what the manual ought to have said, from which you might be able to imply a term, for example. But nonetheless, the manual is king and not the offer letter because of Clause 6.
Thank you.
I'd said I would go next to the authorities. And if we start with Vilela, please, which is at page 11 of the authorities bundle. Before I go into the facts of it, can I make this observation? These authorities deal with, they're mainly in the context, I think all in the context of dismissal. In other words, is there an implied term which prevents the dismissal of an employee who's in receipt of PHI cover? But one of the arguments which arises in the authorities is whether in fact there is an extant right to permanent health insurance payments, because if there isn't, there's no implied term. There's no reason to imply the term. If there is an extant right to be paid, then there is a reason to imply the term, because dismissal would terminate the payment. So that's why the point arises. And the arguments taken in these cases are of subtly different kinds. So one kind of argument is that the employer has taken on a liability itself to pay, but is seeking to argue that the terms of the insurance policy are expressly incorporated into contract between employer and employee. And in those circumstances, the employer is in a position to benefit from some exclusionary rule that the insurance policy contains. And I'll call that an incorporation case. So, for example, the employer has said in terms that it will pay without limit of time, but the insurance policy says that insured payments will stop after 20 years. Can the employer rely upon what the insurance policy says so that it doesn't have to pay after 20 years? And the issue then is one of incorporation. Are the insurance terms incorporated into the contract between employer and employee? That's an incorporation case. And then there's a second argument made in some of these cases, which is that all the employer has done is not itself to undertake an obligation to pay, but simply to subscribe to an insurance policy and to pay over the proceeds. And that's one of the arguments I choose to make here. I call that a subscriber type case. And they have a close relationship, those arguments, but they are logically different. And if we start with Vilela, Vilela seems to me to be an incorporation case. What happens in Vilela is this. If one goes to the Deputy Judge's decision at paragraph 4, page 13, what paragraph 4 tells you in its first half is that there is an inconsistency between what the employer has said and what the insurance policy says. So what the employer has said is that it will pay without any express limit of time, and what the insurance policy says is that pay will cease on leaving service. So what the employer is seeking to do is to bring in that term of the employment policy and to say that it's incorporated into contract between employer and employee. Paragraph 6, one sees there is a dismissal by the employer, but the employee says, well, nonetheless, you, the employer, are obliged to continue to pay. Paragraph 25 sets out what the employer has said in a memorandum about the PHI cover. And it's certainly right to say it has some similarities with what the summary of benefits says here. So, for example, if one looks at the indented text at paragraph 25, the company has introduced a long-term disability scheme which is insured with NEL Permanent Health Insurance Limited. And over the page, one sees about 10 lines down in italics, amount of benefit, and the benefit is said to be a proportion of salary. And if my lords and my lady look a little further down, there are italicized words, payment of sickness benefit. The benefit will be paid to the company, who would pay to the employee a corresponding sum subject to deduction of tax as earned income under PAYE. And I pause there to say, if one looks at all of that language, it does appear as if what the employer is doing is simply taking on an obligation to subscribe to insurance and to act as a conduit for the insurance payments. Not obvious why it could be said that the employer is taking on liability itself to pay. Now, the competing arguments between the parties you can see from paragraph 7a on page 13. And what the employee says at paragraph 7a is that he had a contractual right to benefits paid by his employer in the event of incapacity, and that would remain payable until the earlier of his recovery, death, or reaching 65. And one contrasts that with the employer's argument, which you see from paragraph 10a. Plaintiff's contractual entitlement against the defendant is and was no greater than the defendant's entitlement against the insurers under the scheme, and the plaintiff is bound by the restrictions contained in the scheme which were incorporated by implication or reference into the contract between the plaintiff and the defendant. So it looks like the argument being advanced is an incorporation argument rather than a subscriber type argument. And the deputy judge deals with that point at 29. And what he says at 29a, page 16, is that if that was going to work, the employee would actually have to be given the policy of insurance. And he cites should be Thornton and Shoe Lane parking, or almost certainly wrongly, because the Thornton and Shoe Lane parking concept doesn't ordinarily apply to things like signed contracts. But in any event, he says he'd have to be shown the policy for there to be incorporation. And at 34, he says the letter and memorandum create an obligation on the defendant to pay benefits on the terms and in the circumstances set out, which is enforceable against the defendant as an ordinary contractual obligation. The defendant's arrangements with its insurer are irrelevant. So that's a matter of interpretation of the contractual terms, but it's not obvious that the point being made to the deputy judge is a point to the effect that the employer's obligation is simply to procure insurance and has taken on no obligation itself to pay. Can't clearly see that flowing out of the judgment. We go next to Briscoe, which is page 19. Now, the language in Briscoe is pretty similar to the Vilela language. So if we go to paragraph 5 of the judgment, we see a reference to the handbook. And there are then some numbered indented paragraphs. Indented paragraph 1, the scheme is designed to provide benefits. Indented paragraph 4, it's the company that pays the whole cost of the benefits. Paragraph 6, the amount of benefit is a percentage of annual pensionable pay. Paragraph 9, the insurers pay the benefit to Lubrizol, who then pay it out after deducting income tax. So there is an obvious similarity between the language in the summary of benefits in the instant case, the language that was in issue in Vilela, and the language which is in issue in Briscoe.
In Briscoe, it's all obiter anyway, isn't it? Because the majority held this was, the claimant was properly summarily dismissed for gross misconduct. That has nothing to do with illness or entitlement to long-term disability.
Yes, If my lord goes to paragraph 141, that shows you why this argument arose and why it wasn't decided. So you're in the judgment of, I think, Lord Justice Ward, yes. And what Lord Justice Ward says is that he would have found that there was no entitlement to benefits in that case. But if you look at the last 3 lines, you'll see that that was not a point that was taken on appeal. And in fact, the only reason it ever arose is because Lord Justice Ward himself brought the point up in the course of argument in the court. But it is important to look at it, of course, because where you have very similar contractual wording, and you have on the one hand the deputy judge arriving at a decision, but then a later Court of Appeal authority which does address the point, obiter or not, it's necessary to look at the conclusion and to decide which one of them is correct. And so if we dip into the judgment of Lord Justice Ward, the relevant section begins at page 33, paragraph 124. Is the employer obliged to pay, whether or not it is to be reimbursed by the insurers? Paragraph 127 Lord Justice Ward finds that the objects of the scheme are important. It is to provide benefits in respect of disability of members by sickness or accident. This suggests that what the employer is doing is providing the scheme which provides the benefits. And it goes on to deal with the fact that the insurers, 4 lines up from the bottom of that passage, the insurers pay the company then passes on the benefit less tax. The question is whether that constitutes an obligation to pay remuneration in that sum, whether the benefit is received from the insurers or not. And then at paragraph 130 there are, and 131, 132, there are some older authorities cited, which I don't think help us a great deal one way or another. 133, in my judgment, the case before us is quite unlike those before the court in those earlier authorities. There is no provision making the payment of benefits a continuation of salary so as to impose a primary obligation on the employer to pay them. The employer does not promise to do so. What the employer does promise is to make provision at its expense for employees to become members of the company scheme. Under the scheme, the benefits are paid to the company, and when received by the company, it is obliged to pay them over to the employee. At that stage, and only in those circumstances, are the benefits treated as akin to remuneration, requiring the deduction of tax. I would be satisfied that the company was under no contractual obligation to pay benefits which had not been received from the insurers. So that's what Lord Justice Ward has to say, and it seems to me it's entirely consistent with what Mr. Justice Bodie says at paragraph 66. He says, well, there's no cross appeal. case not argued below on the basis that the defendant would only be liable to the claimant if the defendant recovered from the insurers. So given that the claimant is agreed to have been unfit to pursue his normal occupation, it follows that he must be entitled against the defendant to be paid a sum equivalent to the benefit up until the time of his dismissal on 3 June 1992. But he therefore doesn't go on to make a finding on that particular issue. So there's certainly judicial support for reading a document like the summary of benefits and saying, well, all that is a description of an insurance scheme. And at the very most, what it might do is to provide an obligation on the part of the employer to provide a scheme of that kind. But what it doesn't do is provide any right on the part of the employee to be paid by the employer. The next of the authorities in chronological order is Jowett. And to see the contractual term in Jowett, one goes to Lord Justice Sedley's judgment at paragraph 2. And it's clause 5.3, and it goes over the page onto page 38. Long-term disability, and it's the 1, 2, 3, 4, 5, 6, 7 lines that follow. And you can well see why the argument there that the employer was not undertaking a liability to pay was rejected, because the particular clause makes no reference whatsoever to an insurance policy or benefit or anything of the kind. What it's doing is suggesting that it's the employer itself providing a scheme. So the argument is then rejected by Lord Justice Sedley at paragraph 12 and paragraph 13. And he deals with both issues. At paragraph 12, he deals with the subscriber argument. At paragraph 13, he deals with the incorporation argument. And it to read those. And then the final one of the 4 authorities is Awan, which is at page 172 of the authorities bundle. And the facts are slightly different in Awan. It's not a typical dismissal case, although it does involve dismissal. What happens in Awan is that there's a TUPE transfer. The employee who is receiving PHI benefit transfers over, but the insurance policy doesn't. So the new employer finds itself at that point uninsured and dismisses, and the question is, can they do so? The employer says there's no implied term preventing it because there is no right to PHI payments. The term itself is set out at paragraph 24 of Mrs. Justice Simler's judgment. And it's, if if you look about halfway down paragraph 24, there's a little Roman 2, and it says clause 6, headed pension provided.
Yes.
And the PHI term is at sub-paragraph C. There is then a handbook also, and to see what that says, my lords and my lady will need to read paragraphs 25 to 28 inclusive. And it's, I think, 28 in particular. And self-evidently, an argument either of the incorporation or the subscriber kind wasn't going to go very well here, because the language makes very clear on the face of it that this is the employer taking on an obligation to pay a particular amount. And to see the reasoning of Mrs. Justice similar, one needs to read, I think, just paragraphs 35 to 38, please. Now, if I might tie those threads together in terms of these four authorities. The first observation to make is that it's probably the case that none of them help you, because at the end of the day, the contractual language here is the contractual language here, and we are told, I think, pretty frequently by appellate courts that citing other cases on interpretation is not very helpful when the language is different. But having said all of that, Awan and Jowett don't take you any further at all, because the language in those cases is completely different to the summary of benefits here. And more than that, the conclusions in those cases are obvious, because it's language which doesn't refer to insurance policies or benefits or anything of that kind. It just says the employer has set up a scheme and will pay. So the conclusion follows as a matter of course. Vilela and Briscoe are rather more on point, because the language in both of those cases is similar, and in turn is similar to the language in the summary of benefits. Not identical, but similar. Certainly the important themes, like the reference to an insurer, the reference to benefit, the reference to the way in which payment is made, they're all the same through both cases and the summary of benefits here. In Vilela, it's not clear that the argument was made in the way that I make it to you and have made it to both tribunals below, because it looks like it was an incorporation argument that was being taken rather than a subscriber argument. Can't discern the subscriber argument, at least from the judgment. And in Briscoe, because the point came from Lord Justice Ward in the course of submissions, and there had been no cross appeal, it's only Lord Justice Ward who considers the point. And he says, well, because there's no cross appeal and because I set the hair running, I'm not going to make a finding on that basis. But nonetheless, his reasoning is, I say, impeccable. And it's reasoning that shows you that what I say about the summary of benefits is correct. My lords, my lady, there's one other point I think I want to deal with. I showed you, you asked me about taking this point below. I showed you where I'd taken it in the EAT, but I don't think I showed you where it was dealt with in the ET's judgment. And I'm sorry it's taken me a few moments to find those references. If you go into the core bundle, please. You see at paragraph, well, could I invite you first to read 73? That's slightly the wrong way around. It sets out the claimant's argument first and then my argument. But if you read 73 first. So that's the response to my argument, and the rejection of my argument is at 86 on page 165.
Yeah.
My lords, my lady, may I just take some instructions?
Certainly, yes.
Unless I can assist any further, those are my submissions.
No. It's been helpful, certainly for my part. I welcome a short adjournment while we just take stock of where we are. So please feel free to go out of the room if you need to, but we'll be back very shortly. Yes. Nothing further, Mr. Cohen.
Thank you.
Yes, Mr. Leach.
In responding to the appeal, I propose, firstly, to address one or two points made initially by my learned friend, but in general terms, to take each ground of appeal in turn, and in relation to ground one, first, second.
Well, there's only one ground.
Well, yes. Sorry, if we're not moving on to the cost ground at this point, then I'll take the first.
That's not before us, is it?
Well, the permission was granted in respect of the not the costs cross appeal that permission was refused on, but there is a cost ground of appeal on the part of the appellant, which was granted conditional permission depending on the outcome of ground one.
Oh, I see. My recollection as the judge who granted PTA was that if Mr. Cohen succeeds on the liability appeal, then the costs decision goes up in smoke, doesn't it? Because it's predicated on the basis not only that the claimant wins, but the respondents behave badly as well. But if Mr. Cohen fails on the liability appeal, then I made permission to appeal on ground two contingent on success on ground one.
Yes. Nevertheless, it remains the case, as I understood it, at any rate, that if Mr. Cohen succeeds on ground one, then ground two becomes live.
Yeah.
And I say the cost order does not go up in smoke, actually.
All right.
So it sounds as if actually I do need to address the court on ground two in due course. But in dealing with ground one, I will naturally...
Obviously, Mr. Cohen didn't deal with ground two. I don't know if you're going to deal with it. If it is live, then Mr. Cohen, you need to have the opportunity to take it yourself.
I just want to make this very short observation. I deliberately haven't said any more about it for this reason. I'm acutely conscious that although this isn't a second appeal in CPR terms, it is in reality a second appeal, and the value of the costs award was a low one, unlike the value of this appeal, which is potentially a very high one. I don't want to take up your time with submissions on a point which I think only goes so far. It doesn't seem to me that the cost judgment could stand if you were with me on the merits, and that is the only point I want to make in favour of that second round of appeal.
Thank you. So it doesn't sound, Mr. Leach, if you do need to deal with it, you need to take any great time.
Well, indeed, my lord, although Mr. Cohen may say that the cost award is insignificant, but to my client, that is very much not the case.
Yes.
Yes.
I will address that ground as appropriate. But in terms of setting up the structure of my submissions, I'll take my learned friend's points in turn and the points from my respondent's notice at the appropriate juncture. Just dealing with some preliminary points, as I said first, the point was made by Mr. Cohen that there had been a concession in the EAT, as recorded at paragraph 29 of the EAT's judgment. I simply make the observation, as I do in my skeleton, that although the word concession is used, there was no change of position on the part of the claimant in terms of the case advanced. It was always the claimant's case that the source of the contractual term as to the 5% escalator was the summary of benefits. At first instance, it had been necessary to explain why that remained the case, even when it was believed that the 2005 employee handbook was the manual. But nevertheless, the overarching point was that the summary of benefits was the source of the term, and if the summary of benefits was not of contractual effect, then we don't see reference to a 5% escalator anywhere else. So there was no change of position in the EAT in that respect. The point as to the circumstances under which the 2005 employee handbook fell away, yes, the pleaded case at first instance was that, on the part of the claimant, that was the manual. As Mr. Cohen said, however, because that is what the claimant had been told in his grievance process. It was only during the course of Miss Swyn's evidence that it emerged that that was not in fact the case, and also that there was no other manual dating from 2007 either. So naturally, the submission when it came to closing was that there simply was no manual. That was the change of position in that respect. And there was one further point that Mr. Cohen made, that in the EAT, that the respondent had been prepared to accept that the manual as it had been in 2003 did contain rights to the income protection scheme and indeed the 5% escalator. Now, that was not an act of generosity on the part of the respondent. I use the name respondent as in first instance, and in the EAT, not obviously respondent to the appeal. It was not an act of generosity. The strategy in attempting to make that admission was in order to put on a judicial footing in a judgment that terms as to the 5% escalator were in a manual somewhere, so as to facilitate use of the power of amendment in clause 11 of the contract. And that has been the subject of subsequent litigation. There are currently 2 employment tribunal claims stayed pending the outcome of this case of the same nature on the part of Mr. Langton, because the respondent, subsequent to the first tribunal judgment, sought to effect an amendment of the manual simply by unilaterally changing its terms. And then, of course, if a court were to decide that in 2003 the terms of the manual did in fact contain the 5% escalator, even though nobody can see what such a document might have said, then that would legitimise that course of action and facilitate cancellation of the 5% escalators after the event. That was the respondent's game plan in the EAT, and naturally the claimant declined to take up the offer of that admission. So, moving on then to...
Mr. Leeds, could you just, without developing the argument, just tell us in a sentence each what the 2 subsequent claims are about?
They are further unlawful deductions claims covering later periods in time, because the claimant has continued not to receive 5% escalators, and only certain periods of time can be claimed in retrospect, yes, as unlawful deductions claims, so it's necessary to present
have them in series.
Exactly.
Yes.
And as it happened in between the tribunal's judgment and the second tribunal claim, the claimant had been sent a letter saying words to the effect that we have now amended the manual and you will see that there are no longer 5% escalators, etc., and therefore you're not entitled to it anymore.
Can you just give us the date of that letter?
I couldn't off the top of my head, I'm afraid.
Can you arrange for it to be submitted?
Could you?
Yes, absolutely, yes.
Thank you.
So that makes some sense of Mr. Cohen's reference to jackpot damages. All we're concerned is with the case that led to the award, which is a finite figure.
Absolutely.
These proceedings, but you're describing an ongoing process.
Yes. The point of principle is obviously significant on an ongoing basis for Mr. Langton. Yeah. Probably not relevant, but in the second tribunal claim, a secondary aspect of the claim which is different from the first is that the claimant alleges that the unilateral variation purported to have been effected by the respondent was capricious and therefore itself a breach of contract in any event. So he would maintain that the claim is good in any event.
That's helpful, but
that's not a matter which
we don't and should not know more.
So turning then to the grounds of appeal, ground 1, and in particular the first point, as it's called in Mr. Cohen's skeleton, In a nutshell, what the respondent says is that the manual via clause 6 in the contract of service document is the only provision of contractual effect in relation to the income protection scheme, and therefore that the summary of benefits cannot be of contractual effect, as both the Tribunal and the EAT found. The summary of benefits is simply a summary, so one has to, for the purposes of construction, disregard the summary of benefits, and indeed it would seem the offer letter, which I say incorporates the summary of benefits. I say that is, unsurprisingly, not the proper approach. The proper approach, I say, in the first instance, is to recognise that this case concerns an employment contract, not a deed. I notice that Mr. Cohen included in the authorities bundle an extract from Lewison, which concerns deeds. I say that has no bearing on the issues in this case. The context of employment is important, and if authority is required in that respect, I would refer very briefly to the Supreme Court's judgment in Wood at paragraphs 10 and 13, where...
Page 158 onwards.
Yes.
Is 164.
So in conducting the task of construction, paragraph 10, depending on the quality of drafting, it's maybe appropriate to give more or less weight. This is just above letter C on 1179 to elements of the wider context in reaching its view as to the objective meaning, and words to similar effect can be found at paragraph 13 at the end of the sidelined passage. In the course of interpretation, the court may be particularly helped by considering the factual matrix and the purpose of similar provisions in contracts of the same type. That's the starting point in the exercise of construction, I say. In this case, the next important matter is to recognise that in the contract of service document there is no entire agreement clause. So, in the absence of such a clause, I say the first point can go no further. Mr. Cohen is inviting the court to conclude that the only place one can look for terms as to the income protection scheme is clause 6 and the manual which it purports to incorporate. But I would make the observation that in the very act of purporting to incorporate another document, it cannot be the case that clause 6 on its own is the sole source of terms, because it itself seeks to refer to another document. But as I say, there's no entire agreement clause, and in those circumstances it is entirely appropriate and correct to look at other documents. And again, I would refer very briefly to Carmichael and National Power in that respect, tab 1 of the authorities bundle. And what Lord Irvin has to say at page 2047 at letters B to C. It's the sideline passage in a nutshell. The factual circumstance is slightly different in that case because the construction of the contract involved consideration of parole evidence. That's not a feature here. But my point is simply that in the absence of any indication that the parties intended clause 6 of the contract and the manual to constitute the only source, then it must be appropriate to look at other documents.
But these are 3 documents all sent together.
Yes.
So, speaking for myself, it doesn't seem to me that you need the extensive case law about background, factual matrix, negotiations, what one party said, what the other party said. The question is whether the third document, the summary of benefits, is part of the contract.
Well, indeed. My point here, my lord, is that in the absence of anything in the contract of service document to say, for example, although you may be sent other documents at the same time, they don't have any contractual effect. The only place where you find the contractual terms is in this document entitled Contract of Service. In the absence of any indication of that nature, then the starting point is that, of course, the other documents that were sent prima facie are part of the patchwork of contractual documentation. That phrase patchwork I have lifted from the judgment of Lord Justice Underhill in Pimlico Plumbers. I haven't referred to that case in my skeleton. I included it in the authorities bundle. I should say as well, my lords and my lady, that in an effort to keep down the number of authorities in the bundle, I didn't include the Supreme Court judgment in that case. I have brought copies with me should the court wish to see it. I don't understand the Supreme Court's judgment to affect the statement of principle made by Lord Justice Underhill in particular. And turning to that judgment at tab 9.
We haven't got the tabs, at least I haven't.
It's page 122.
122.
So, different issue in that case, but at its core was a question of construction of the contractual documentation, and it would be most instructive, I would suggest, to look at paragraphs 96 to 98 in the first instance, where we see submissions made on behalf of the company about the contractual documents in that case. So at paragraph 96, there's a submission made about the content of what's called the 2009 agreement. In broad terms, that is a contract document. You see it summarised from paragraph 22 of the Master of the Rolls judgment. It replaced an earlier iteration from 2005. Both of those documents profess to incorporate another document called a manual. And you can see between paragraphs 96 and 98 the drawing out of an apparent conflict between the 2009 agreement as to the obligation to offer work and the terms of the manual as to a normal working week. And the submission was made further down in paragraph 98 that the provisions, insofar as the provisions of the manual were inconsistent with the express terms of the 2009 agreement, the contract document, then the manual had to be ignored in favour of the contract document. That submission, that was on the basis of a passage from Lewison, which has since been updated in the light of this judgment. And that submission was rejected by the Master of the Rolls at paragraph 109. And it's also rejected by Lord Justice Underhill. And relation to his judgment, I turn first to paragraph 127. Now there, this court takes matters further even than the passage of the speech of Lord Irvine in Carmichael, because in this case there was an entire agreement clause in the contract document. That is clause 6.3 that Lord Justice Underhill is referring to. And we see that set out at paragraph 41. But even in those circumstances, the idea that the 2009 agreement had to take priority over everything else was rejected. The phrase, the patchwork of different materials, I take from the very last sentence of this paragraph. And we see he goes on explicitly to reject the submission that had been made on the basis of Lewison at paragraph 138. He says, by letter H on 154 of the authorities bundle, on ordinary principles, it was the job of the judge to attempt to resolve the inconsistency in the way which she believed best reflected the intentions of the parties. And then right at the end of that page, I do not believe that the principle stated in Lewison is determinative in a case of this kind. A case of this kind being a case where a patchwork of materials has to be considered. He goes on to say the realities of the situation as shown by the evidence adduced, or in that case, the evidence adduced was parole evidence as to how the contract operated in practice. Is a different factual matrix from here. But I would say the reality in this case is that there is no manual. We don't know what it says or said. So it cannot conceivably be the case that clause 6 and an invisible manual should be given precedence over the summary of benefits, which we can see in its plain terms. So naturally I say this is a patchwork of sources case. What is the patchwork here? Well, as you've already indicated yourself, my lord, certainly the offer letter, the summary of benefits, the contract of service document or statement of terms are part of the patchwork, but there are other documents as well. There's a 2004 document which reiterates the statement of benefits. And we see that in the supplementary bundle. Findings were made about it by the Employment Tribunal in its judgment. Paragraph 12 thereof, as it happens. The actual document itself is in the supplementary bundle at 161. It's 161 of the supplementary bundle. It should be a document headed Rewards, Benefit and Environment.
Oh, I see. What is 153?
There were two versions of the summary of benefits in the papers for the tribunal hearing. One supplied by the claimant, one supplied by the respondent. I think they are materially the same,
Yes.
but they're one from one side, one from the other.
And 161 is a third.
This is a different document.
Yes.
Findings were made by the tribunal at paragraph 12 that the claimant, that this dated from 2004, and on 162 you see reference to the income protection scheme, what benefits are provided. There's inclusion of the 5% escalator there. And again in 2007, my lady, my lords, you'll hopefully be aware from the tribunal's judgment, there was a slide presentation in 2007.
I'm assuming.
and we see those at 220. Oh, sorry, the slides themselves are
193.
195, and there are a lot of pages, but happily not many of them are pertinent. At 197, you see reference to the income protection scheme as part of the harmonisation plan, and then the overall impact slide over the page shows that the plan was expected to have a neutral impact on the scheme, and that same position is repeated at 202. And then the employees were told at 205 that they were to receive a set of documents following the slide presentation, and the findings of the tribunal are that the claimant signed his documents. We see that form at 220.
Yes.
He didn't actually have to opt into the income protection scheme, but no indications of any change to the income protection scheme at this point. And the oral evidence at trial was that it was around this time that the 2005 handbook was withdrawn and ceased to be effective. There was no other manual available thereafter, the claimant, of course, commencing receipt of his benefits in 2009. So actually, there was no evidence at all of the terms of any manual, either as at the date when he started employment or at the point when he commenced receipt of the benefits under the scheme. There was simply...
Was there evidence that there was a handbook, they just didn't have it, or that there was no handbook at all?
Well, the respondent's case was that the 2005 employee handbook was the manual, but that case imploded in the oral evidence, and there was no suggestion that there was any other manual. No other document was provided. No replacement manual from after 2005 has ever been provided or seen by the claimant. We know that there should, according to the contract document, have been a manual in 2003, but nobody knows whether there actually was one, or if there was, what it said. The only evidence was the 2005 handbook. And there was another handbook from 2012, which you do have before you. But that was it.
Would you accept that it's a likely inference that there was a manual in existence in 2003 and its terms as regards long-term disability protection were not inconsistent with the summary of benefits?
I would not accept that, my lord, because the tribunal declined to make any findings at all about what the manual may or may not have said explicitly. Paragraph 53 of its judgment, it refused to draw any such inference. And I would argue that Mr. Cohen actually somewhat mischaracterised what the EAT said about that. What the EAT said about that at paragraph 75 of its judgment was not to make a finding that it must be implied that the manual that existed in 2003 was in the same terms as the summary of benefits. Is a subtly different point. What he's saying, Judge Auerbach is saying, is that the objective reader of the summary of benefits would assume that its terms would not be inconsistent with the manual. But that's not the same thing as actually finding that that is, by implication, what the manual said. So there's been no finding at either level below that the manual in 2003 said the same thing as the summary of benefits. The respondent would very much like a court to say that in order to provide it with a defence for its subsequent claims. But I would not accept it would be appropriate to draw that conclusion without being able to see the document. With absolutely no evidence at all, assumptions cannot be made. It's frequently the case in the employment context that a multitude of documents are inconsistent with each other, and tribunals routinely have to grapple with complications caused by one document purporting to say one thing and another document purporting to say something else. So it would not be right in my submission to assume that the manual in fact did what the respondent would like it to have done.
Can I just ask you a question, Mr. Rich? In paragraph 75, which you've mentioned, the EAT said the objective reader would infer that the manual and the summary benefits were marching in step, as it were. The EAT went a little bit further in paragraph 79 and said, there seems to be a reference back to paragraph 75, but it's a bit stronger. As I've indicated, the only objective inference that the reader of the contract of service would draw back the manual is it would not say anything materially different about IPP from what the summary said. So do you disagree with that reasoning, the EAT?
What I say is that, taken with 75, care must be taken in construing what Judge Auerbach is saying there. He's, in my submission, referring to the objective contracting party, and that Mr. Langton would not have... it's about the expectation of the party looking at the documents. The expectation would be that the manual would not say anything materially different.
So is it looking at the maybe different coins, but the maybe different sides of the same coin? What he's saying is you can't say that the manual would say anything materially different, and that's different from finding the manual said exactly the same thing.
Exactly my point, Lord. It's a critical
He's
distinction.
really just double-checking his working by saying, well, there's nothing to suggest the manual said anything different. And that's a finding below the finding that it actually said exactly the same thing.
That's exactly my point, my Lord, yes.
But why does it matter for this claim? I understand why it might matter in the later claims, but I thought your case on this claim was whether or not anything was said in the manual. The summary of benefits is part of the contract. If it was amendable at all, it was only amendable by clear notice being given to the employee concerned. There was no such notice, and we don't have to decide what would have been the effect of clear notice being given.
It was the respondent's case in first instance that the variation was critical and the question of notification was important, but it was not the claimant's case. The claimant's case was always, even when it was believed the 2005 handbook was the manual, that because of clause 22, which I'll come on to when I deal with my respondent's notice, it didn't matter because the summary of benefits was king and not the manual. And the question of notification of variation didn't come into it because the contractual term was to be found in the summary of benefits, and the power of variation is a power to vary the manual. So unless the term as to the income protection scheme, and in particular the 5% escalator, is in the manual, there's no power to vary it. And even in the 2005 handbook, there was silence as to the escalator, and if one looks at it, that handbook expressly disavows any contractual status, in fact. The simple case was summary of benefits is king, and there's no power to amend that document. That's always been the claimant's case.
But why do we have to decide that? Because part of your case is, even if that's wrong, and there is a power to vary on notification, there was no such notification until, I don't know, what, 2018, or you haven't haven't given us the letter yet. But until that letter, there was no such notification. Therefore, it doesn't matter in this case.
Yeah, that was true in the tribunal, yes, but that was only a secondary point in answer to the point taken by the respondent. The claimant's case was simply that variation was entirely irrelevant because the relevant term was not found in a place that was susceptible to variation at all.
But your fallback would be, if it is susceptible to variation, it could only be on notification to the employee. There was no such notification, so you say you hold this judgment and it'll be for the tribunal in case number 2 to decide the question of whether there is any power to vary at all.
Well, I maintain in this court that the question of variation is irrelevant to your determinations, my lord, because the ground of appeal that's advanced is that the sole source is clause 6 and
Yes.
the manual, and I say, in support of the tribunal and the EAT's judgments, that that's wrong, and the source is the summary of benefits. And if I'm right about that and the lower judgments are upheld, then the question of variation simply doesn't arise. So, having set out what I say the patchwork of sources is in this case, it's important to consider briefly what that patchwork in fact says. You've been taken to some of the documents already by Mr. Cohen. I perhaps will try not to detain you by doing it all over again, but what I would say, firstly, in relation to the contract of service document, is to reiterate the point made in the course of submissions by Mr. Cohen, that clause 6 does not refer only to the manual. It refers to the offer letter. And actually, I think, having said I wouldn't, I will go to the contract document and clause 6.
Page 139.
139. So the extent and circumstance, there's a false dichotomy drawn by Mr. Cohen between the extent and circumstances being set out in the manual and an outline being provided in the offer letter, because what is outlined in the offer letter are the extent and circumstances of the benefits. Those are plain words of incorporation in my submission. The offer letter is incorporated into the contract by means of this clause. It's not a disjunctive phrase, it's and. They're set out in the manual and outlined in the offer letter. Clearly, the objective intention was that the offer letter would be reliable. And in the ordinary course of things, I would suggest that an individual being offered employment, the very first thing they would read is the offer letter. And what does the offer letter say in this case? My Lord Justice Bean has already identified. The income protection plan, as it's called in this document at 135, is part of the remuneration package. Now, this is very significant for later arguments because it is part of the claimant's pay. There is no reference in this letter to any third party, to any insurer. There is no reference to any manual in this letter either.
No, I noticed that.
Well, I correct myself. there is reference to a life insurance policy in respect of the life insurance plan, but in relation to the income protection scheme, there is no reference to an insurer or to the manual, only to the summary of benefits on 136. And the words of incorporation there are for further information. Those are clear words of incorporation as well, and there's, in fact, if it's needed, authority for that proposition. Keeley and Fosrock in the first instance. Cat 5. We see at paragraph 34 on page 49 of the authorities bundle.
I'm so sorry, I didn't catch the paragraph number.
Page 49, and I didn't get the
Paragraph 34.
34.
Thank you.
Highly relevant is the importance of the provision to the overall bargain. Here, the employee's remuneration package, what he undertook to work for, well, that's exactly this case, I say. A provision of that sort, even if couched in terms of information or explanation or expressed in discretionary terms, may still be apt for construction as a term of his contract, providing it is not in conflict with other contractual provisions. Now, in passing, I make the observation here that there are no other contractual provisions for the terms of the summary of benefits to conflict with, because there is no manual.
And the two documents we do have, the summary of benefits and the letter, are consistent each with the other.
Indeed. And for good measure, it's a lower level judgment, but in A1, if that's the correct pronunciation, I apologise to the claimant in that case if it's not, but the simple point there, again, is that information, the provision of information, was considered without difficulty to constitute words of incorporation. We see that at paragraph 24.
That's page 175, is it?
Yes, no. So towards the bottom, on the right-hand side of page 175, you see in the middle, Roman numeral 2, clause 6, setting out reference to the disability plan in that case, and that the scheme would pay an annual payment of 2/3 of salary. Information on this benefit plan, including eligibility requirements, are to be found in the company booklet. No suggestion that provision of information is not adequate to constitute words of incorporation. I say clearly in the summary of benefits, the offer letter in this case, reference to the summary of benefits for information constitutes incorporation. And when one turns to the summary of benefits itself, I say clearly its terms are apt for incorporation, established principles. So I've been looking at the version of the statement, the summary, sorry, at 145.
Yeah.
It clearly sets out at the bottom when benefits will be provided. It provides for the point in time when that will commence. It provides for the 5% escalator. It stipulates over the page that the benefit will be 75% of salary, which I say is significant in conjunction with the offer letter stating that the scheme is part of the remuneration package. It's entirely in line with the circumstances of AWAN as it happens. It specifies that Kramer pays the whole cost. There's a clear and certain statement of what the benefit is and how it works, and there's certainly enough to enable anyone to see or calculate how much has to be paid. And that was the litmus test really in Jarrett in the first instance. I'll refer the court briefly to that judgment, which has already been taken to. But there, Lord Justice Sedley says, in particular at paragraph 13,
Page 30.
it's page 40.
40.
Yeah.
Yeah,
What's
paragraph
required?
13. Yeah.
By letter B, what's required is for sufficient to be spelled out for the parties to be able to quantify the amount payable. And the complaint by Mr. Underhill QC, as he was at the time,
He seems to have been in virtually all these cases in one way or another.
rejected by Lord Justice Sedley, however, making the point at the end of that paragraph that even if the statement of the term is not perfect, if it can be made to work, then it remains apt for incorporation.
Yeah.
And that's the situation here in my submission.
But for my part, you don't need to labour these points in this case because there is no contrary account of what the payments were to be. We haven't got the manual. What we do have are the two statements which are entirely at one with each other.
Yes, but as I understand the ground of appeal, it's to say that summary of benefits is not contractual. So I'm seeking to explain why it is contractual.
Yes. While I've interrupted, I have to be at a meeting with the Master of the Rolls at 1 o'clock. I think that clock's slightly slow. I make it now 12:54. So I'm being selfish. Could you, in about 5 minutes' time, find a convenient moment to pause?
Yes, absolutely, my lord.
Thank you.
I would also refer on this point to the case of Sparks, which also summarises Keeley and Fosrock. But for this point, I'll use the Sparks summary. That's tab 8, page 106, authorities bundle. And you will see, my lady, my lords, that summary of Keeley is set out at 15. There's also reference to a lower level judgment in Hussein cited with approval. And the ultimate question is set out at paragraph 18 by Lord Justice McComb. But the question is simply whether the provision is apt for incorporation.
You say, of course, it's apt for incorporation. It couldn't be clearer.
Indeed, yes. And but he goes on at paragraphs 30 to 34 to express his conclusions, and in the course of doing that, at paragraph 31 in particular, he refers back to what I will call the Lord Justice Dyson test, which is, if one were to extract the provisions from the incorporated document, copy and paste them and stick them into the contract document, could anyone seriously say that they're not contractual terms? That's the litmus test, and I would say, obviously, that would be true here in relation to the 5% escalator. to finish off before the break, my lord, I would simply make the observation by reference to Keeley again that, and you'll see an extract from it, paragraph 15 of Lord Justice McComb's judgment in Sparks. So it was said by Lord Justice Auld in Keeley that the fact that the staff handbook was presented as a collection of policies does not preclude their having contractual effect, if by their nature and language they are apt to be contractual terms. So I say, on the basis of that, that because the summary of benefits is called a summary, doesn't make any difference at all. What matters is the substance of the document, not the label that's given to it. And as it happens, we've seen two other later iterations in 2004 and 2007, which don't use the name summary of benefits. The documents are called something else. The fact that the word summary is used is of no importance whatsoever. And that, my lord, would be a convenient moment to break.
Very good. So, Mr. Leach, how, it's not to rush you, but just to inquire, how much more time do you think you might need after we resume? You're dealing still with the first of the 3 points, as I understand it.
Yes, the other 2 points are very much shorter.
Yes.
So,
And in fact, you've dealt with in part 2 and number 2.
Yeah.
So half an hour?
I'm not sure I could go quite that fast, my
There
lord.
we are. Well, we'll see.
Okay.
Good. And then obviously you'll reply.
5 minutes, no.
5 minutes. Very good. Good. 2 o'clock real time. So that's probably about 3 minutes to 2 on the clock. Thank you.
All right.
Very much.